Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers detentions, reasonable suspicion, and open carrying, and is brought to us by KTVU Fox 2's channel and Pinac News' channel. Be sure to check out the description below and give them the credit that they deserve. This will be another double feature episode, so be sure to stick around for our coverage of both of today's interactions. On July 29, 2015, California resident Don McComas was standing in his driveway, attempting to attach his boat trailer to his truck when he noticed Officer Dave Rodriguez of the Rohnert Park Police Department slowly creeping down the street in his police cruiser. Mr. McComas found the officer's behavior suspicious, so he pulled out his phone and began recording from his driveway.
He's now circled the neighborhood. Now he's headed back towards me. He's been very slow in all of his driving. Clearly didn't like that I was pointing my camera to videotape him, but he came around the area very slow. He's on and off his microphone right now. He's now calling in my license plate number of my excursion. He thinks he's being funny now.
Hi. Go take your hand out of your pocket, okay?
No, sir, I haven't done nothing. I've done absolutely nothing, no.
Hey, seriously.
Put your gun down, really?
Edward 10.
After engaging in a quote-unquote camera battle with Mr. McComas, Officer Rodriguez exits his patrol car, approaches Mr. McComas, and orders him to remove his hand from his pocket. When Mr. McComas refuses to obey, Officer Rodriguez unholsters his firearm and continues to approach and order Mr. McComas to comply. Generally, for an officer to give commands that restrict a citizen's freedom, such as ordering them to remove their hand from a pocket, there must be reasonable suspicion that the citizen is engaged in criminal activity. In the 2018 Third Circuit case of United States v. DeCastro, the court concluded that a simple request to remove hands from pockets without additional coercive conduct does not require reasonable suspicion, and that officers are free to ask citizens to remove their hands from their pockets without invoking the citizen's constitutional protections. However, the court emphasized that if an officer orders a citizen to remove their hands from their pockets, then they must first have obtained reasonable suspicion. The key distinction in determining whether an officer has the authority to order a citizen to remove their hands from their pocket is whether or not the officer had reasonable suspicion to detain the citizen at the time of the order. As noted in the DeCastro case, along with many others, quote, police conduct rises to the level of a so-called seizure when, by means of physical force or a show of authority, a person's freedom of movement is restrained. Now, in this interaction, it could be argued that Officer Rodriguez's act of unholstering his firearm served as a quote-unquote show of authority that could have transformed this stop from a consensual encounter into an investigative detention. This would require that Officer Rodriguez meet the standard of reasonable suspicion before ordering Mr. McComas to remove his hands from his pocket, or else the interaction could violate Mr. McComas's constitutional rights by restricting his movement without legal justification. Now, we will discuss whether Officer Rodriguez actually had reasonable suspicion in a moment, but for now, it is important to understand that reasonable suspicion is required for officers to issue orders that restrict a citizen's movement, and it is arguable that if Officer Rodriguez did not have reasonable suspicion when he issued his orders, then he may have illegally detained Mr. McComas by unholstering his firearm to gain Mr. McComas's compliance.
Start me another one.
This one's really got a gun on me. No. You don't touch me. You don't touch me.
I'm at that address. Start me another unit.
You don't touch me.
Hey, man.
No, you don't touch me.
When I tell you to take your hand out.
I've done nothing.
Okay.
Nope.
You need to relax.
You go away.
Okay. I don't go away. I stay where I am. You can go in your house if you want, or you can stay out here. But you don't keep your hand in your pocket. Okay?
My hand can be in my pocket. There's nothing in there. I've done nothing. What have I done?
I'm telling you.
Answer me. What have I done? Why'd you get out of your vehicle?
You're taking a picture of me. I'm taking a picture of you.
Officer Rodriguez explains that the reason he exited his vehicle to engage with Mr. McComas was because Mr. McComas was allegedly taking photos of the officer. Now, while Officer Rodriguez would be well within his authority to exit his patrol car and engage in a consensual conversation with Mr. McComas, the officer would need to meet the standard for reasonable suspicion before he can order Mr. McComas to do anything. The only explanation that Officer Rodriguez offers for his behavior at any point during the encounter is, quote, "You're taking a picture of me, I'm taking a picture of you," essentially implying that Mr. McComas was stopped for recording the officer. Although the Supreme Court has not directly ruled on the right to film police under the First Amendment, this is likely due to the court considering the matter as having been resolved by the circuit courts. In the 2011 First Circuit case of Glick versus Cuniff, the court held that, quote, "The filming of government officials engaged in their duties in a public place, including police officers performing their responsibilities, fits comfortably within these principles. Gathering information about government officials in a form that can readily be disseminated to others serves a cardinal First Amendment interest in protecting and promoting the free discussion of governmental affairs." Several other circuit courts have reached the same or similar conclusions over the years, including the Ninth Circuit Court, which has jurisdiction over California. In the 1995 case of Fordyce versus City of Seattle, the Ninth Circuit noted that citizens have a, now quoting, "First Amendment right to film matters of public interest," and implied that video recording public officials is protected under the First Amendment. The precedent of the Fordyce case has been significantly expanded through more recent Ninth Circuit cases, and it remains a highly referenced case in regards to video recording. The act of video recording public officials while in public is well protected by the First Amendment, but the act of recording from your own private property enjoys even more protections. It doesn't appear that Mr. McComas left his property at any point during the interaction, and it is highly unlikely that a court would find that a citizen recording an officer from their own property would be enough evidence to grant Officer Rodriguez the authority to issue commands to Mr. McComas.
You take your picture and leave.
Okay. I don't have to leave.
Neither do I.
So, I told you to take your hand out of your pocket. I just want to make sure you don't have a weapon.
You know I don't have a weapon on me.
Okay. I don't know that.
You do that. I'm completely
Well, I have my
clear.
gun out.
Wrong.
Okay.
You have your gun out because you're a police officer. You're trying to intimidate me, and this is going all over YouTube.
Put it on.
This is horrible. Trust me, I will.
Okay.
You guys have done enough to my family.
Okay. I don't even know who you are.
That's why you just happen to slowly approach my house, stop in front of my house,
I don't even know
and then
who
keep
you are,
going.
dude.
So that was just random. That was just random?
Yep.
So you stopped.
Okay.
You didn't stop at
What's
anyone's
wrong
house.
with you, man?
You didn't stop at anybody's house but mine.
What's wrong with you?
Your station is corrupt.
Oh, okay. Are you some kind of a constitutionalist,
No, sir.
crazy guy or something like that? Is that your
Is that what you're going after? Is that where you're going?
I'm
Are you throwing
asking
claims
you.
around?
I'm asking you.
Are you throwing these around?
What's that?
Are you throwing labels around?
Why are you doing this?
Why are you sitting here with your gun out at me? This is why I'm doing this, to protect myself from you.
Okay. All right. Well, you just stay right in front of me, and then we'll be all fine. Okay?
Am I being detained? Have I been accused? Are you accusing me of a crime? Are you suspecting me of a crime?
If I did, I would arrest you. Okay? So, go ahead and have a nice day. Put it on YouTube. I don't really care.
I will, sir.
Okay?
Getting my stuff from my car.
Okay.
Officer Rodriguez returned to his patrol car and left the scene without further incident. Following the encounter, Mr. McComas filed a federal civil rights lawsuit alleging that Officer Rodriguez violated his right to free speech and assembly. Officer Rodriguez was denied qualified immunity, and the case was set to go to trial, but a settlement agreement was reached, and Officer Rodriguez retired from the department during the legal proceedings. The sum of the settlement was never publicly released. Overall, Officer Rodriguez gets an F for likely violating Mr. McComas's First Amendment rights, utterly failing to engage in any form of de-escalation, and maintaining a hostile and confrontational attitude throughout the encounter. Although he did not place Mr. McComas in handcuffs or physically harm him in any way, at no point in the interaction did any of Officer Rodriguez's conduct serve a legitimate legal purpose, and it appears as though this entire interaction was meant to do nothing more than intimidate Mr. McComas. Rather than greeting Mr. McComas in a welcoming and helpful manner that you would expect from a community service provider, Officer Rodriguez chose to harass and intimidate Mr. McComas based solely on the fact that he was video recording. Officer Rodriguez's behavior is contrary to the fundamental tenets of policing and community service, and this interaction showcases how the actions of one officer can destroy the reputation of a department and make a lasting impact on a citizen's perspective of law enforcement officers in general. Mr. McComas gets an A+ for refusing to allow Officer Rodriguez's intimidation tactics get the better of him, remaining calm and collected throughout the interaction, and following up this encounter with the proper legal action. Not only was Mr. McComas able to remain calm during the interaction, but he also had the presence of mind to begin recording as soon as he noticed Officer Rodriguez acting suspiciously. At no point did Mr. McComas yell or curse at the officer, and his refusal to obey the officer's commands were stern and well articulated. Mr. McComas's conduct exemplifies how citizens should assert their rights calmly and effectively when confronted with potentially unlawful police behavior. His approach serves as a model for others who find themselves in similar situations, and demonstrates the power of staying composed and using the legal system to seek justice. I commend Mr. McComas for demonstrating the fundamental aspects of asserting civilian rights and how to follow up that assertion with the proper legal action. Let's move on to the next interaction. In August of 2015, free speech and open carry advocate Caleb White visited the town of Bald Knob, Arkansas, after receiving reports that a citizen had been arrested and prosecuted for open carrying a firearm in the town a few weeks prior. Mr. White, along with a friend, decided to conduct a First and Second Amendment audit on the premises of the Bald Knob Police Department. After a few minutes of filming in the parking lot of the department, the two were confronted by Officer Chester Wright, and the interaction that followed was recorded by Mr. White.
Both of y'all walk over to my vehicle right now.
For what reason?
Right now, because I'm telling you to. Do not play with me, because I'm telling you to.
Name and badge number.
Walk to the car.
Name and badge number.
Walk to the car until I figure out what you're doing.
I just told you what I'm doing.
Put your hands on the vehicle, both of them. Put your phone down, sir.
No, I'm videotaping
You can
this.
record me.
I have every
don't
right
care.
to record you.
You do.
My hands are on the vehicle.
You're back here taking pictures of
I'm
the
doing
vehicles
nothing
back.
illegal. You come up here with your holster unhooded,
I haven't cleared
hand on
anything.
your weapon,
I haven't cleared anything, have I?
screaming orders.
Yes.
Are we being detained?
You are for
Under
a
the
minute.
suspicion of what crime?
Huh?
Under the suspicion of what crime?
Taking pictures.
No,
back.
that ain't a crime. Terry versus Ohio
good.
says that you have to have reasonable, articulable suspicion of a crime to be able
That's
to
good.
detain me.
That's
What
good.
crime do you suspect me of? If you do not suspect me of a crime, I will be free to go.
27 ball now.
Yes, sir. They're parked outside by the water office now, but they had walked around back.
10-4. I'll have them both right up front. Wait, go ahead. Have some back.
Are we being detained?
I have 803 around.
You're being detained.
Under the suspicion of what crime?
Huh?
Under the suspicion of what crime?
Listen.
No, there is no
You
listen.
understand-
Unless you can tell me under the suspicion of what crime I'm being detained, I will be free to go.
You're not free to go.
Okay, then
You
I'm
are
being
not free
illegally
to go.
detained. Am I being
You
illegally
are not
detained?
being illegally detained.
What crime do you suspect me of? Or are you in violation of Terry versus Ohio, a Supreme Court ruling that says that you must have reasonable,
You can talk-
articulable suspicion?
You can talk and say all this.
Yeah, so can you.
All that you want. When you come up here,
You lawless jack think you run this town, and you don't.
what are you doing?
I'm doing nothing illegal. I'm doing everything that's
You're-
within my constitutional rights to
Okay.
do so.
All right, you're back here looking suspicious with firearms.
Looking
Just to
suspicious isn't a crime.
just to draw attention to yourself.
Looking suspicious isn't a crime.
It is when you got a
No,
firearm
it's not a
on
crime.
your side, sir.
No, it's not.
Yes, it is.
No, it's not.
Yes,
what,
it is.
What law are you citing that says it's illegal
What
to
law
look
am I
suspicious?
citing?
Officer Wright informs Mr. White that he is being detained due to his so-called suspicious conduct of carrying a firearm while filming different areas of the police station. And and Mr. White argues that suspicion is not a crime and that his detainment is unlawful. As mentioned before here on ATA, officers do not need suspicion of a specific crime in order to detain a citizen for investigative purposes. In the infamous 1968 Supreme Court case of Terry versus Ohio, the court held that in order to detain a citizen, quote, the police officer must be able to point to specific and articulable facts which, taken together with rational inferences from those facts, reasonably warrant that intrusion. In other words, officers do not need to point to a specific crime they believe that a citizen may be committing in order to detain them. Instead, the officer must witness or be aware of certain facts that might lead them to believe a crime is being committed. Another widely misunderstood aspect of reasonable suspicion is the consideration of the totality of circumstances. In the 1981 Supreme Court case of United States versus Cortez, the court held that, quote, in determining what cause is sufficient to authorize police to stop a person, the totality of the circumstances, the whole picture, must be taken into account, meaning that courts will consider all the factors surrounding a particular arrest or detention when determining whether or not it is lawful, rather than focusing on any single element for the justification of the stop. For example, a citizen dressed in all black while walking down the street in the middle of the day is not inherently suspicious, but a citizen wearing all black sneaking around the outside of a bank at night could certainly be considered suspicion and warrant investigation. The act of wearing black clothing, while not illegal or particularly suspicious on its own, could be considered suspicious if other potentially criminal context is introduced. However, in recent years, a growing number of circuit court cases have reaffirmed that purely innocent behavior cannot be used as a basis for reasonable suspicion. In the 2013 Fourth Circuit case of United States versus Black, the court rejected the notion that reasonable suspicion can be formed by, quote, patching together a set of innocent, suspicion-free facts, which cannot rationally be relied on to establish reasonable suspicion, emphasizing that some criminal element must exist to develop reasonable suspicion. We will discuss the implications of Mr. White's conduct and possession of a firearm later, but it is important to note that reasonable suspicion does not need to be supported by a specific crime, and a court would consider all the available facts surrounding the encounter to determine whether Mr. White's detention was lawful.
What law are you
Sir,
citing that says it's illegal to look suspicious?
If I get a call about two guys,
1050.
I'm 1050. If I get a call about two guys, they're around there taking pictures of cars.
Still not
They
illegal.
have sidearms.
Still haven't cited a law. Still haven't said what we're
that's
doing
fine,
illegal.
but I have reasonable suspicion
Of what
hold you
crime?
here.
Of what crime?
We'll figure that out here in a minute.
No, we won't. We will figure that out now. If you
Okay.
cannot reasonably articulate a crime that you suspect me of committing, I will be free to go.
All right, here you go.
So you're legally detaining me.
We'll see.
Ever heard of DeVere versus the United States? A citizen who's doing everything lawfully in a lawfully allowed place is not a reason for detention.
So
That makes two Supreme
you're not
Court
here
cases
being-
you're violating.
You're not here trying to make a spectacle of yourself, right?
No,
You're not.
no.
Okay.
I'm actually doing a story on you.
That's a good one, too.
Yeah, it is. It's going to be real great when you're added to it.
Okay.
A lot of fun.
It's gonna
My
be
lawyers are going to have a lot of fun with y'all too.
a Good deal.
You corrupt little podunk town cops think you run the place,
Mhm.
and you don't.
And you think just because you come up here and cite a couple of laws and carry your firearm, that you're going to be on the internet and be famous.
I don't want to be famous.
You don't.
I don't give a shit.
Then what are you doing then?
I'm writing a story.
A
I am
story.
doing a story on
Who
you.
you
I was
work
getting
for?
B-roll.
Who you work for?
It's none of your business.
No, I'll bet. $827. Time frame when 803 will be here.
Sarah also has a trooper en route to you. 803 should be there momentarily.
What crime do you suspect me of committing?
Right now, I'm not sure if you've done a crime or not.
Okay, then I'm not detained.
You are detained.
You cannot unlawfully detain me. Did you realize that the Supreme
I
Court
gotta- listen,
the Supreme
I gotta
Court
call-
has ruled that an unlawful detention is akin to assault and battery?
Is it?
Yes.
Okay.
That's the Supreme Court, the highest law of the land.
Okay.
If you had any integrity, you would honor your oath to the Constitution, which you and I have both taken multiple times. This dude doesn't realize I'm a commissioned officer in the state of Arkansas. So again, what are we being detained for?
You're being detained.
For?
Trying to figure out what you're doing here.
No, you have to have reasonable suspicion of a crime. Do they send you to the academy, or they just give any Badge
Give
around here.
anybody a badge around here.
Seems like
That's
it.
exactly the way it works.
Seems like it. Running code through town for a non-emergency.
Okay.
I don't know, be 97 one then.
Morning.
What are y'all doing?
Exercising constitutional rights and being illegally
He
detained.
wants to be on the internet.
He said I'm detained and he cannot articulate a crime.
Listen to me.
No, I'm not going to listen to you.
Yes, you are, because you're on city property.
City property is public property.
You're not allowed to be on city property with a firearm.
Wrong.
You're not allowed to be on city property with
What law is that?
my chief. I just got the phone with my chief. You guys are
Your chief don't make laws.
See, that's what I've been putting up with the whole time.
Okay.
I am here doing a story on you
Let
guys.
me see your identification.
No, sir.
Excuse me?
I do not have to present identification unless I'm being detained for the suspicion of a crime. You cannot take my phone and stop my recording. I have the right to record.
Oh, I'm recording too, so
That's
it's okay.
fine.
You can record. Hello. But the thing about it is, you guys cannot be on city property with a weapon.
Officer James Jackson arrives on the scene, and after failing to grab Mr. White's cell phone from his hand, informs Mr. White that he cannot be in possession of a firearm on city property. Mr. White argues that city property is public property, and that there is no law against carrying a firearm on public property. Now, going back to the case of United States versus Black that we mentioned in the previous section, the Fourth Circuit specifically stated that, quote, where a state permits individuals to openly carry firearms, the exercise of this right, without more, cannot justify an investigatory detention. The 1997 case of United States versus DeBerry, which Mr. White mistakenly referred to as a Supreme Court ruling, took place in the Seventh Circuit Court and aligns with the logic of the Black case. Arkansas is an open carry state, meaning that the act of openly carrying a firearm in a public place cannot be the sole justification for detaining a citizen. However, other factors in this situation may play a role in determining the legality of Mr. White's detention. Although Mr. White is correct that city property is technically public property, that does not mean that a city isn't allowed to control how the property is used by members of the public. In the 1966 Supreme Court case of Adderley versus Florida, the court held that, quote, the state, no less than a private owner of property, has power to preserve the property under its control for the use to which it is lawfully dedicated, meaning that municipalities are allowed to create reasonable restrictions for the use of certain buildings, such as prohibiting firearms on the premises. Furthermore, a court could consider a police station to be a quote-unquote sensitive location in regards to the prohibition of firearms. As the Supreme Court noted in the 2008 case of District of Columbia versus Heller, nothing should, now quoting, cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings. More recent cases, such as the 2022 Supreme Court case of New York State Rifle and Pistol Association Inc. versus Bruin, have reaffirmed the notion that certain government buildings can lawfully prohibit firearms on their premises. Although courts have not directly ruled on whether police stations qualify as quote-unquote sensitive locations in this context, police stations are government buildings that require a heightened level of security, and it is entirely possible that the Bald Knob Police Department could have lawfully enacted a prohibition on firearms on the department's premises. Contrary to Mr. White's assertions, a prohibition of firearms on public property does not necessarily need to be codified into law in order for a respective government to enforce such a policy, as the courts consider the Second Amendment to be subject to reasonable restrictions. It should be noted that the laws and jurisprudence surrounding the right to bear arms is still a hotly debated topic among legal scholars and the courts, and the landscape of Second Amendment protections is still evolving, leaving the subject steeped in legal gray areas and differing interpretations. Without knowing what took place before the video began, or the specific policies of the city of Bald Knob and the Bald Knob Police Department at the time, it is nearly impossible to determine whether the Bald Knob officers were within their authority to detain Mr. White without a court ruling on these specific circumstances. However, if no policies existed that explicitly prohibited firearms on the department's property at the time, then it is highly unlikely that any of Mr. White's conduct displayed in the video would have risen to the level of reasonable suspicion.
And what law states that? Okay, just so you know, the cop ended my recording on purpose, which is also illegal. I mean, you guys don't know basic fundamental Supreme Court rulings. Oh yeah, sit over there and mock me all you want.
On the internet famous.
Yes, you are.
You are.
I'm not the one in the video. You two are. Am I still being detained? Am I being detained? Anyone?
What?
Am I being detained?
You're being here for an investigation.
Am I being detained?
You're being here for an investigation.
Am I being detained?
Keep your hands up.
My hands are on the card. Am I being detained? If I'm not being detained, I will be free to leave.
Right now, at this time, you're not free to leave.
So I'm being detained.
You're being under investigation.
Of what crime? No, it's not. Hold on a minute. If you don't have reasonable suspicion of a crime, I'm free to go. It'll be all right. This is deprivation of rights under the color of law, so we'll get to sue them personally. We won't have to go for the city. We can go after them. Huh? My lawyers will take care of it. I'll split whatever we get with you. What am I being detained for? What?
Yeah.
Huh? I'm a commissioned officer. It's my vehicle, and I'm a commissioned officer in the state of Arkansas. No, he did not. He didn't say a word. It's on video.
So whose vehicle is this? Are you? No. It's your
Yes.
Okay, are you a police officer?
I'm a commissioned officer in the state of Arkansas, yes.
You are? Can I see your identification?
No,
Why?
because I do not have to legally provide you identification.
Okay. You guys are not allowed on city property or on the police department's property, so you guys need to leave.
All right, bye.
One of the officers informs Mr. White that he is no longer allowed on city property, and the video abruptly ends with Mr. White leaving the scene. Both Mr. White and his unidentified friend were released without further incident. It is unknown whether Mr. White filed any complaints or pursued any legal action against the officers or the city of Bald Knob. Overall, the Bald Knob officers get an F for displaying a fundamental misunderstanding of the Second Amendment and the legalities surrounding it, potentially violating Mr. White's Fourth Amendment rights, and for maintaining a hostile and condescending demeanor throughout the interaction. Although there may be a legal argument that potentially justifies their detention of Mr. White, it is clear that the officers were not aware of it at the time of the interaction, and it appears as though the officers were operating under the false assumption that it is a statutory violation to possess a firearm on all public property at any time. This misconception is contrary to the very tenets of the Second Amendment and the Constitution as a whole, and understanding the basic principles of how these concepts apply to everyday life is a major aspect of police work. Rather than attempting to engage in a productive and positive dialogue with Mr. White and his friend to ascertain their motives, the Bald Knob officers elected to immediately detain Mr. White and attempt to force him to identify himself. At no point did the officers consider any investigative tactics less intrusive than a detention, and it is this type of indiscriminate overuse of authority that can ruin the reputation of a department. This interaction highlights the importance of constitutional training and de-escalation techniques, and how the lack thereof can significantly impact a department's relationship with its community. Mr. White gets a B+, because although he was somewhat mistaken on certain legal principles and case law, he asserted his rights in a relatively polite but stern manner, complied with the commands of the officers despite believing them to be unlawful, and remained calm and collected throughout the interaction. Now, unlike Mr. McComas from the first interaction that we covered in this episode, Mr. White intended to carry out an audit on the Bald Knob Police Department, which means that his conduct is subject to a greater degree of scrutiny. Conducting an audit is essentially an advocation for constitutional rights and an act of protest against the government's ability to regulate certain rights. Individuals who choose to conduct an audit must possess a deep understanding of the legal nuance surrounding these types of interactions, or else they risk embarrassing the entire auditing community and facing potential jail time. While it is certainly arguable that Mr. White's conduct did not rise to the level of reasonable suspicion, and his detainment was patched together through a series of innocent behaviors that were purely lawful, as mentioned earlier, it is nearly impossible to speculate how a court might rule in this circumstance, especially considering the rapidly evolving nature of Second Amendment case law. While I commend Mr. White for conducting a relatively successful audit, I would caution other auditors who intend to engage in similar behavior to consider gaining a thorough and updated understanding of the case law surrounding the Second Amendment, along with the local policies regarding firearms on certain premises. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.